In this section, we are going to present an overview of federal laws and regulations that pertain to charting. Nearly every state has state laws that are closely aligned with these federal laws. Just as we encourage our patients to face their anxiety, we should expect no less of ourselves. For example, the False Claims Act is real. Fraud cases are filed under the False Claims Act. Any person who knowingly submits a false claim to the government is liable for double the government's damages, plus $2,000. And the federal government can go back 10 years to examine Medicaid and Medicare charts. Many fraud investigations and lawsuits arise from citizens who successfully bring what are called qui tam lawsuits against people who defraud the government. Citizens who are successful are granted a large portion of what the government recovers. Title 18 of the United States Code is the main criminal code of the federal government of the United States. The title deals with federal crimes and criminal procedure. Section 1347 pertains to federal, state, and private healthcare fraud. Section 1347 states whoever knowingly and willfully executes or attempts to execute a scheme or artifice to defraud any healthcare benefit program shall be fined under this title or imprisoned not more than 10 years or both. Referring to false statements relating to healthcare matters, 18 Usc Section 1035. Section 1035 states, whoever in any matter involving a healthcare benefit program, knowingly and willfully, makes any materially false, fictitious, or fraudulent statements or representations, or makes or uses any materially false writing or document, knowing the same to contain any materially false, fictitious, or fraudulent statement or entry, in connection with the delivery of or payment for healthcare benefits, items, or services, shall be fined under this title or imprisoned not more than 5 years or both. 18 U.S.C. Section 1343 states, whoever, having devised or intending to devise any scheme or artifice to defraud, or for obtaining money or property by means of false or fraudulent pretenses, representations, or promises, transmits or causes to be transmitted by means of wire, radio, or television communication in interstate or foreign commerce, any writings, signs, signals, pictures, or sounds for the purpose of executing such scheme or artifice, shall be fined under this title or imprisoned not more than 20 years or both. So, what do we know? In summary, we know that licensed psychotherapists are required by contract and law to create medical records for psychotherapy services paid for by health plans. Are you both ethically and legally required to create a medical record for psychotherapy services? Psychotherapists have had their license suspended for losing a patient's record, so the answer is yes. I am sorry to pile more concerns on you, but professional liability insurance may not cover the legal costs for a provider who is prosecuted for allegations of criminal conduct. Did you know that a chart note may be amended with excerpts from psychotherapy notes during or prior to an audit or other legitimate request for information? I am going to shock you with what my attorney told me. He said if psychotherapists don't have completed chart notes, they should be engaged in creating, completing, repairing, or recreating those chart notes. Failing to do that might be considered negligent or knowingly breaking the law. A good faith effort to correct errors and mitigate harm can change a referral for criminal investigation to a civil or informal compromise. Healthcare systems have departments that routinely audit and correct chart notes as far back as 3 years. Charting and audits are a source of mental distress among psychotherapists. Are you ethically required to seek help if your state of mind is preventing you from charting? In this section, we're going to present information about the intersection of psychotherapy notes and federal minimum necessary guidelines. Is it ethical to include all the sad and tragic details of patient's life in a medical record? Probably not. And especially not if your ethical goal is to avoid harm and protect privacy. The purpose of a medical chart is not to document as much as you can about a patient's personal and private life. What is the minimum necessary requirement? According to 45 CFR 164.502b and 164.514d, therapists are to restrict the disclosure of confidential information to the minimum amount of information needed. The minimum necessary is for a legitimate purpose and is open to interpretation. Psychotherapists must use their clinical judgment. They should consider: is there a need to know? Is there a risk of harm? Is harm more likely than not to happen? The core healthcare activities of treatment, payment, and healthcare operations are defined in the Privacy Rule at 45 CFR 164.501. A covered entity also is required to develop role-based access policies and procedures that limit which members of its workforce may have access to protected health information for treatment, payment, and healthcare operations, based on those who need access to the information to do their jobs. A covered entity that participates in an organized healthcare arrangement may disclose protected health information about an individual to other participants in the organized healthcare arrangement for any healthcare operations activities of the organized healthcare arrangement. Additionally, this means you must provide patients' medical records to a health plan if you wish to be reimbursed. However, what you provide should be the minimum necessary. This is where you must use clinical judgment. Keep in mind that for purposes of self-auditing or allowing staff to audit your records, you need not give health plans more information than you allow your staff doing the same job. Here is an example taken from the Yale University Minimum Necessary Policy. Medical staff must make a reasonable effort to disclose or use only the minimum necessary amount of protected health information in order to do their jobs. They can disclose information requested by other healthcare providers if the information is necessary for treatment. Physicians and providers who are directly involved in the care of the patient can see PHI. Providers can disclose to consulting physicians or for referrals, but not to people who don't have clinical responsibilities. Physicians must be careful about what they disclose to other staff members, such as billing department workers or providers not involved in the care of their patient. Here are some additional guidelines used by Yale University. Do not put anything into a patient's medical record that might cause significant harm or is likely to cause more harm than good. Use general rather than specific language whenever possible and avoid direct quotes of patient statements. General language examples include interpersonal stress, family conflict, painful memories, distressing recollections of past events, affect regulation, guilt or regret over past behavior, etc. The use of screening, progress, alliance, and satisfaction questionnaires can solve many legal and ethical problems pertaining to minimum necessary information requirements. Many questionnaires ask general questions that can provide more valid information than one can get from patient disclosures. Also, reliable, valid, and useful screening, progress, outcome, and satisfaction measures can actually protect patient privacy. Standardized questionnaires that rely on general questions instead of patient-quoted statements can be very useful. From a clinical perspective, what needs to go in the patient's medical chart? We argue that sensitive, intimate, personal, private, and confidential information, which may help describe a patient's history, should only be entered in the patient's medical chart based on a risk of harm analysis. I am now going to read an excerpt from a psychotherapy note. The note has been altered to protect the patient's privacy. When he was little, his brother, Sam, abused him, forced him or pressured to lick his penis. Feels like it was his fault. I didn't have to do it. Depression? Developmental trauma? He does not want this in his record. We argue that such a statement belongs in a psychotherapy note rather than a patient's medical record. For purposes of a diagnosis, that level of detail is not necessary or useful to share with the patient's physician or care team. Further, we seldom diagnose a patient on the basis of what that patient states. We diagnose the patient on the basis of their whole story, which we cannot document verbatim. Would it be more appropriate to document that the patient reported being abused as a child, or to say the patient has an ACE of 8? There are many problems entering such information into a medical record. First, it would betray the patient's trust, and it could harm the therapist-patient alliance. The patient may not remember saying that at a later time, or they might change their story as they remember more, or they might, in the future, download their files from their patient portal, and their father might find and read them. Or perhaps the patient was sexually harassed at work, and the offender's attorney now wants a copy of their medical record. Sensitive, intimate, personal, private, and confidential information may be helpful in a diagnosis. Psychotherapists should not put such information in a medical record to support a diagnosis or to justify services. Records are not intended to be a repository for information that is not relevant to treatment and could harm the patient. A diagnostic conclusion may or may not be valid. A fundamental rule of statistics is that the validity of a conclusion cannot be higher than the square root of the reliability coefficient of the declarative facts. This is why diagnosis is valid about 50% of the time. This helps explain why the DSM and ICD diagnostic systems, at least according to the NIMH, have no scientific value or validity. Where do we put patient session information that is not pertinent to the purpose of a medical record? This might include the specific appointment, therapy discussion, session content, therapist impressions and concerns, working diagnosis, information that may become relevant, and information that is of little or no use to others who are not involved in the therapy at the time the notes were made. What are psychotherapy notes? According to Title 45, Code of Federal Regulations, CFR, Final Rule 2003, psychotherapy notes are defined as notes recorded by a healthcare provider who is a mental health professional documenting or analyzing the contents of conversation during a private counseling session or a group, joint, or family counseling session, and maintained separate from the medical record, actually separate in a different location. Colored paper in the same chart is not considered separate. Additional information, that is for the purpose analysis, may be duplicated in a psychotherapy note. Information such as medications or start times must be recorded in the patient's medical records and noted solely in the psychotherapy note. This rule is rather confusing because it assumes a paper chart note. In 2003, there were few if any electronic medical records. Attorneys interpret this differently. Psychotherapy notes may include some information in the medical record, additional information that is not in the medical record, and information that may become part of the medical record in the future. Psychotherapy notes are granted special protection under HIPAA due to the likelihood they contain particularly sensitive information, and also because they are the personal reflections of the patient or the treating therapist. The primary purpose of psychotherapy notes is to help the psychotherapist recall the specific session, therapy discussion, session content, information that is not relevant, information that may become relevant, information that is of little or no use to others not involved in the therapy at the time the notes were made.